Hi, my name is Suha Abu-Jazar and I'm an associate at Stewart Sharma Harsanyi, practicing primarily in the area of family law. I'm going to be speaking briefly today about obtaining an emergency protection order in the family law context. Oftentimes, individuals who are separating or divorcing find themselves in situations of family violence. If you find yourself in such a situation, an option available to you may be obtaining an emergency protection order or an EPO. An EPO is essentially a restraining order. It requires that the respondent, being the person who you have obtained the EPO against, stay a certain distance away from yourself, from your home, from your work. And an EPO is typically obtained in cases where a family member has threatened violence or acted on violence and there is an immediate need for protection. You may obtain an emergency protection order on your own by attending at the Provincial Court Family Division. You will have to appear before a judge of the provincial court where you will have to explain why it is that you believe that you require immediate protection from your family member. If the judge is convinced that you are in need of immediate protection, then an EPO will be issued. The EPO will remain in effect for 9 business days. At which point it will be set for a review at the Court of Queen's Bench. Prior to your review date, yourself, the complainant, will have an ability or an opportunity to complete an affidavit where you will set out in greater substance the evidence of abuse, the reasons for why you're obtaining your emergency protection order, or why you want it to remain in effect, rather. The respondent, being the person who the EPO is against, will also have an opportunity to prepare an affidavit in which he will likely set out why he or she believes the EPO should lapse on the review date. All affidavits should be served on the other party and filed with the court prior to the review date in the Court of Queen's Bench. On the review date itself, yourself and the respondent, the complainant and the respondent will need to be in attendance at the Court of Queen's Bench and will appear before a justice. You will present your case in morning chambers, and there's typically about 10 to 15 minutes allocated for each case in morning chambers. So that's not a whole lot of time. But within that short space of time, you'll have an opportunity to explain, or the complainant will have an opportunity to explain why he or she believes that the EPO should continue to remain in effect. The respondent will have an opportunity to explain why he or she believes the EPO should lapse. If the judge, or the justice rather, feels that he can make a decision as to whether the EPO should lapse or continue to remain in effect within that period of time, then he will either extend the EPO for a period of 6 months to a year, or cause the EPO to lapse effective the review date. Sometimes, particularly in rather contested cases, the justice cannot make a decision within that short space of time, the 10 to 15 minutes allocated to morning chambers, and he or she will consequently set a hearing date. Hearing dates typically take place several months in advance, and on the actual hearing date itself, the complainant and the respondent will have an opportunity to provide live evidence and further evidence as to why they believe the EPO should either lapse or continue to remain in effect. If your EPO does remain in effect, then there are serious consequences associated with breaching the EPO for the respondent. If the respondent is found to have breached the EPO, he can be arrested and required to appear before a provincial court judge, where penalties could include a fine or jail time. So that is, in a general sense, how one can obtain an emergency protection order. Thank you for watching this video and for visiting our channel.